Our speaker today, Kellie Slappey Nothstine, actually is a former intern of the Locke Foundation. Her former boss just walked in the room, Becky Gray. And so Kellie is one of those who has gone on to just do tremendous things, has a very successful career, and she has agreed to join us today to talk about an issue that's been in the news a lot. We've been hearing a lot over different state laws, House Bill 2, we've heard from the Obama administration, and the phrase Title IX thrown around a lot. So we thought, okay, really, what is Title IX? Let's get someone in here who can explain to us actually what it is, what it means, and what the changing nature of Title IX could mean to North Carolina. Let me tell you a little bit about Kellie since she left the Locke Foundation. Well, first of all, right now she is the Title IX coordinator for Campbell University, so she's an expert in this field she's speaking about today. She also worked in the Office for Civil Rights within the Department of Education's Chicago branch. Her job there was to review Title IX complaints. So she's pretty much seen it all in terms of the gamut of what people think Title IX is about and what it really is about. She also formerly worked over at the General Assembly, serving then Representative Hugh Blackwell. She holds a master's in education policy and a law degree from Loyola University, Chicago. And as I said, she spent a lot of time here at the Locke Foundation helping out with some of the fine research that our folks produce here, and then of course our own Becky Gray uses to talk with legislators about the decisions that they're looking to make. We're very delighted to have back with us today Kellie Slappey Nothstine. We're going to do the wardrobe change here. So. Is that going to work? Okay, good.
Thank you. So while I did go to law school, I am not a constitutional law scholar. A lot of what House Bill 2 and the ACLU lawsuit deals with a lot of things outside of Title IX. I'm going to focus my discussion on the Title IX. So if you have questions about that, I will either make up an answer or say no comment. That is what I do, is the Title IX aspect. I have the unique perspective of, I deal with the law in a very practical sense every single day on a college campus, that I have to actually make sure that our college is compliant with Title IX and deal with the in and outs of what that policy looks like in practice. And then, like Donna mentioned, I did work for the Department of Education before, kind of on the other side, reviewing and making sure colleges were in compliance. So that's what I am going to speak to more of within the House bill and the ACLU lawsuit. So as they teach you in law school, the first thing you want to do is start with the plain text. So that's what we're going to do here. Title IX is part of the Education Amendments of 1972. This is exactly what it says right here, this little short blurb. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So most often on college campuses, I'm going to give you a scenario that I deal with, is you have a boy meets a girl at a party. They get drunk. They go back to his place. They start kissing. The boy wants to go further. The girl's not sure. She hesitates. The boy pulls out a condom. She opens it. Was there consent? So you're probably thinking two things. What in the world does that have to do with the law? And second, didn't know we were going to get so serious so fast. And that's what I want to talk about, is what the law is. What does it look like on a college campus? And then the expansion of the law that now includes issues like House Bill 2, and kind of give you that context and that background and history of how did we get from this to this. And it's important because not just for North Carolina, but for a national stage as a whole, as you can see here. What happens in North Carolina with this law has ramifications for the entire country. So backing back up to the law. It prohibits discrimination on sex in education programs. And most people's familiarity and idea of Title IX is that it's about athletics, and it's about having more women in athletics. And that is such a small piece of Title IX. It has to do with so much more than that. It also has to do with having more women in STEM studies, so science, technology, engineering, mathematics, making sure there's not discrimination against students that might be pregnant or parenting, like a non-traditional student. That's what Title IX is. And I should also clarify, it has to do with a college campus. So you hear that no discrimination based on sex. You might think of like Title VII or Title VI, which is also national origin or ethnicity. And Title IX is only sex, only college campus. So the other thing is that people think it only has to do with women. And that's also not true. It has to do with anyone and everyone that's on that college campus. Male, female, it has to do with male-male relationships, female-female, faculty and staff, or even faculty and staff and a student. So that's where you might see that overlap of Title VII, whereas that's discrimination with an employer-employee. Title IX is within the education setting. So if I have a faculty staff member against another faculty staff, you're going to have both that are going to interplay here. But that's really how that looks. The most severe expression of sex-based discrimination is violence, and that includes sexual assault. Also included in that is attempted completed rape, sexual harassment, stalking. The thing here that the law is trying to prevent is a hostile environment on an education campus that, going back to the law, a person be excluded from participation in or denied the benefits of. So going back to the very beginning, we talked about this consent scenario. So this is how I see Title IX, unfortunately, on Campbell University, is that you have a guy and a girl start dating. They think it's going to be a great idea to sign up for all of the same classes together. Halfway through the semester, they break up. And maybe it's an ugly breakup. And now they're in the same classes together, and it's a small classroom setting. It's a small campus. And maybe there's elements of he's sexually harassing her, inappropriate things he's being said to her. Maybe there's an element of stalking. So much so that she doesn't want to come to class anymore. She doesn't even want to be on that college campus. A hostile environment has been created. That's where you see that discrimination being played out, that it's denying someone the participation in or the benefit of that educational experience. The law has kind of three magic words: severe, persistent, pervasive. So something like a rape is so severe, it's a single incident that it can create that hostile environment, discrimination. Something like harassment or stalking might be not as severe, but if they happen multiple times, it becomes persistent and pervasive that now we have a hostile environment and we've denied her or him the benefits of that education experience. The other thing I want to talk about real quick so that you just kind of get the full picture is that Title IX has, so the fun thing is it has to do with federally funded. So if you don't want to receive federal funds, you don't have to be in compliance with Title IX. There are only two colleges, Hillsdale and Grove City, that are not under Title IX, that don't receive federal funds. And all colleges, public or private, receive federal funds either through grants, loans, so they all have to be compliant within this. When Title IX was passed, there was a religious exemption. And what this says is that if a school is controlled by a religious organization, they do not have to comply with aspects of Title IX that might not be consistent with their religious tenets of such an organization. So like a Liberty or a Carson Newman or a Bob Jones. When Title IX was originally passed, you only had a very handful of schools that even applied for this exemption. In 2014, under the Obama administration, they started to expand the language of Title IX to include sexual orientation and some of those homosexual relationships under that. Obviously, you had several schools starting to apply for this exemption because they argued that those things that would make them do under Title IX would be outside of what they believed as a religious organization. So currently, we have 27 colleges that are exempt from Title IX and another 9 that are pending application. So now that you kind of know what the law is, I want to talk about the expansion of that language and that what got us here to the House Bill 2 thing. And to do so, we're going to play a little Schoolhouse Rock. You have the 3 branches of government. You have federal agencies, and federal agencies, their job is to interpret or implement the law, and sometimes that means creating regulations and rules. And that is great that they have that ability because we need them to be able to interpret laws for our time as things change, culture, technology. The bad thing is if they create rules that maybe violate our individual rights. We don't want a federal agency arbitrarily making up regulations of this is what the law means. So in 1946, the Administrative Procedure Act was passed to ensure a certain level of protection for our federal agencies and what they could create rulemaking. And what the law says is that for a federal agency to come up with a regulation or a guideline, they have to go through this process. So the first thing is notice. They have to give notice of the proposed rule. It has to be published in the Federal Register. It has to include the date that the rule will become effect, the legal authority the agency has proposed the rule under, and the substance of the rule. Next, they have to solicit public comments. This can come from interested parties. It could come from you or I. A lot of times this is corporations that the rule might affect or have an interest in it, interest groups, lobbying groups. There's no enumerated time period of what that public comment looks like, but it's normally 30 to 180 days, give or take. And it can be reopened if they don't receive enough comment or certain important voices in the field haven't come forward. They then have to consider all the comments that were made when they draft the final version of that rule. So you have this rulemaking procedure. Keep that in mind as we move on to the Department of Education. So Department of Education, within them is OCR, Office for Civil Rights. They have 12 offices, and they enforce federal civil rights laws. North Carolina is under the DC office. There's an office in Chicago. That's where I worked. Within OCR, you have these civil rights laws. Title IX is included in that. Also would be like special education laws, age discrimination, Title VI, Title VII aspects, things that would all be civil rights within the education setting. So OCR, every now and then, issues something they call guidance letters, and they call them Dear Colleague letters. And they will send these out to schools to tell you, here's some guidelines or ideas of how to be in compliance with the law. And going back to, we talked about that rulemaking procedure, this is where it becomes kind of tricky, is ideally, the Dear Colleague letter, they're selling it as guidance, would be guidance language, like, to be in compliance, you could do this, this, and this. If it's a rule, it will have rule language, so like you should. You're required to do this. You have obligations to do this. Does that make sense? We're going to look at a letter to kind of walk through the difference. And if it has rule language, it has to have gone through that rulemaking procedure that we talked about. So in April 4th, 2011, the Department of Education issued a Dear Colleague letter, and that's the first time you see that Title IX coordinator popping up. So beforehand, there had been a statistic that had been released, and it's actually been recently reaffirmed, that 1 in 5 women face sexual assault on a college campus. So this kind of became the platform for the Obama administration, the Department of Education, of we have to do something about this. We'll issue a Dear Colleague letter to give people guidance on how they should handle these cases. So here's the letter starts off, kind of that statistic that I talked about. Then the letter goes into, this is all guidance language, that this letter will add supplements. This letter concludes by discussing proactive efforts schools can take to prevent sexual harassment and violence. So can is guidance language. Then the letter takes a turn. Starts using more Title IX requirements, schools' obligations to respond, rule language. Procedural requirements pertaining, recipients of federal funding must comply. Title IX regulations require. So going back to this dichotomy, the Office of Management Budget, another federal agency, has said that if something is a guidance letter, it should not include mandatory rule language such as shall, must, require, or requirement. This letter from OCR uses the word require, requirement 51 times, and they pass it off as guidance. I also want to mention that when they passed off this letter, they did so without any notice, no comment period, and there was no publication. In 2015, the U.S. Court of Appeals in D.C., which sees most regulation cases, came out and said that any agency action that imposes a new obligation or legal requirement on the public is a substantive rule and requires a notice and comment period, which OCR did not do and has not responded to. So we have a federal agency going outside of the rulemaking process. We have a federal agency on the other side that says, this is what rule versus guidance looks like. A federal court has stepped in and said that that's rule language, not guidance. And that is kind of the context that brings us now into House Bill 2 and the ACLU lawsuit and that bigger expansion of Title IX. Side note, if you're interested in that kind of stuff, FIRE, Foundation for Individual Rights and Education, is a fantastic organization. They are actually great with anything that has to do with education and the law. So there's a search bar. I just typed in like Title IX, Dear Colleague Letter Violate, and there's a whole article on if they violated the law. If you just type in Title IX, you will get the gambit back, some great resources. You could probably give your own Shaftesbury after you spend a couple hours on this website. So that's that. So transitioning into House Bill 2.
But, yeah, one quick question. When was Title IX created?
2011, the Dear Colleague letter.
Title IX.
Oh, 1972 is like the original language of the law, but that Title IX coordinator wasn't till 2011.
I was just wondering why it was created before the Department of Education, and all of a sudden the Department of Education jumped in. Just go ahead.
So House Bill 2 says, specifically prohibits schools from allowing transgender students to use bathrooms consistent with their gender identity. The law says schools may only permit a student to use the restrooms, locker rooms, or other such facilities of the gender listed on the student's birth certificate. And obviously the law does all kinds of things, but we're going to focus on the Title IX aspect. And just to make sure we're all on the same page, I want to point out that sex and gender are two very different things. Sex is, anatomical, biological, whereas gender is more of a state of being. A lot of people say, like, what you identify as. So on its face, why shouldn't you be able to plug in gender and sex into Title IX? So when you're dealing with issues like stalking, sexual harassment, absolutely. Like, nobody should be harassing or stalking anyone, period. When you look at the practicalities of, if you say Title IX, no discrimination based on sex, also includes issues like gender, sexual orientation, this gets a little bit more complicated on a college campus. So take an issue, like bathrooms or even athletic teams. You have, Title IX is supposed to be making sure like women have, a certain amount of women are in the athletic programs, but then also women's teams. So you have a young man who, maybe he's a male, but identifies as a female, wants to be on that women's volleyball team. So you have a space that we've created to make sure they're not discriminated on, and now he wants to be a part of that space. It becomes kind of a battle of individual rights over, they both have rights, he absolutely has rights, but is it under Title IX? That's kind of the question here of, you can't just widen our arms and encompass this because you're creating other problems under that. So the courts had kind of come down all over the place. In 2014, the Department of Education said this, that all students, including transgender students and students who do not conform to sex stereotypes, are protected from sex-based discrimination under Title IX. Under Title IX, a recipient generally must treat transgender students consistent with their gender identity in all aspects of the planning, implementation, enrollment, operation, and evaluation of the single-sex classes. So this is tricky because this is the Department of Education and it's not formalized law. This is kind of one of their memo, Dear Colleague letters. And you have courts, lower courts, district courts all over the place, some saying that Title IX, sexual orientation, is not part of Title IX, and others saying it was. And the Department of Education comes in with this other voice. So you have these individual school districts as well, but North Carolina is the first state to implement a statewide law saying that where someone could and couldn't go to the bathroom. I also want to throw out too is that House Bill 2, it deals with a lot of things, but it doesn't touch private universities. So in March 2016, the ACLU filed a lawsuit challenging the House Bill 2, saying that it violates Title IX. And this is what one of the parts of the lawsuit, that it excludes plaintiffs from participating in, denies the benefits, and subjects plaintiffs to discrimination in educational programs and activities on the defendant's UNC's campus on the basis of sex. So they wanted to take that sexual orientation and say that it was part of Title IX. I want to time out, fast forward a little bit. You have a case in Virginia. This is a school district, and they had said that students can't use bathrooms based on biological gender, which is pretty much the same thing what the North Carolina law says. A student, 16-year-old boy, filed a suit saying that, you know, it should be, and part of his argument towards the judge is he used the Department of Education's language saying, you know, that statement I read before, that transgender students and all of this was part of Title IX. The district court judge wouldn't consider it and obviously ruled against the young boy. The Fourth Circuit, which controls North Carolina as well, reviewed the case in January, and in April they came down with an opinion, 2-1 decision, and they remanded the decision. So something I think that got lost in the media is that people were like, oh, it got overturned. And remanded means that it just sent the case back down to the lower court. And they said, you have to review this case, and you have to do so with the Department of Education's understanding of Title IX and sexual orientation. And this is kind of alarming because all of a sudden you have a federal court that has the opportunity to review something that a department, you know, we talked about how they've kind of gone around the rulemaking procedure. A federal court now has the opportunity to either say, hey, what you're doing is right, but you got to go through the rulemaking procedure, or even if they want to say that is the reading of the law, this is why. And the opinion doesn't do that. For the most part, it kind of just defers to the Department of Education. You know, in layman's terms, it's like, hey, what you guys said. There's no legal reasoning or justification. Sending it, you know, back down. So, going back to that bigger scale of what does this mean for North Carolina? What does this mean? National ramifications. So the thing here is that the Fourth Circuit is the highest court that has reviewed this kind of opinion so far. And I think they're going to have another chance with the ACLU lawsuit. It's going to go back up there. And I can even see the Supreme Court stepping in, maybe to give guidance, because we are all over the place right now. But what happens within North Carolina, the Fourth Circuit, is going to have national ramifications, because you're going to have a higher court that either is going to affirm this kind of language and interpretation again, and that sets a precedent for a federal agency to make rules without doing the rulemaking procedure, but also not giving that legal reasoning to why and how that we create these rules. The other aspect of what this means for North Carolina is you have the federal funding piece that I briefly touched on. So they're threatening pulling federal funding. That has ramifications for the nation of, if they do pull federal funding, other states, other school districts, or that's going to influence how they respond with Title IX and with how that they view sexual orientation within that sphere. If they don't pull federal funding, that has ramifications, obviously. And the big thing I kind of want to end on, and this is why I'm here, is that it's so much bigger than bathrooms and who gets to use what bathroom. I've also heard people say it's a fight over sex and what sex means and gender and sexual orientation. It's so much bigger than that. I think this is a fight about saying what a federal agency can do outside of the law. We have a process that they have to go through, and they've surpassed it. And when a federal court had the opportunity to rein that back in, they did not. So that's what alarms me or concerns me, is that I think they're going to have that opportunity again. And I'm afraid that they don't. And then what kind of precedents are we setting for federal agencies when it comes to other rulemakings and other guidance that they may issue? So, thank you.